All right, y'all. Part 6. So this is going to be pretty short. I just want to go over. I got 2 questions in the YouTube comments on part 5 that I wanted to flesh out a little bit. The first one is from Steep Descent. He asked, or she, I guess, but probably a he, whatever. Could you go over the Amazon claim you made in the previous video, video 5? And I won't read the praise from it, but thanks for the praise. So in the previous video, I alluded to the fact that Maddox likely violated the Amazon terms of service when he used them to promote his show. And the reason I say this is because the episodes that were brought to you by Maddox's affiliate show started off with a tagline, something along the lines of the best debate in the universe is proudly, or our show today is proudly brought to you by our Amazon affiliate page. Please visit the page at madcast.com/Amazon or something, amazon.com/madcast, I don't know. Who cares? Or click the link on the page. The reason I said it may violate the terms of service, and I think ultimately it did, and as such there are no Amazon affiliate pages listed, no links left on the Madcast Media Network. So either the affiliate program ended for him, or he violated the terms of service and the affiliate program was terminated. So to tell you where he violated this, let's see. The main thing is if you just Google the Amazon affiliate program terms of service, you'll get this nice little contract. Terms of service, again, these are adhesion contracts. I mentioned them in a previous thing. Adhesion contracts are the devil. I think they're completely unjust contracts. So, brief aside, an adhesion contract is a contract that you agree to based on your purchase or undertaking of some endeavor. For example, when you buy an airline ticket and you just get a little piece of paper that says that you have a boarding pass to get on a particular flight at a particular time going to a certain destination, that's fine. But the actual purchase of that obligates you to follow the airline's term of service. The agreement to fly on the plane comes with all sorts of conditions that you're agreeing to through this contract of adhesion. Most people have no idea what's in the contract. For example, most people don't know that they can drag you off of an airline, right? Like we saw this with United. They just decided that someone was not allowed to be in their seat because they had a different use for it. And really, in that adhesion contract, you pretty much assert that you have no right to the seat. Like, you don't have a property interest in the seat. You're there solely as a guest, licensee of the airline, and you're screwed if you want to complain about anything. If they want you off, you technically agreed to the contract that you've never seen, never signed, and couldn't negotiate the terms of. You agreed to that by purchasing the ticket. So adhesion contracts, I expect in the near future, over the next probably decade really, are going to get just ripped up because their use is really widespread, especially with the internet right now. Because like, how do you negotiate a contract with Amazon, for example? Like, they put up the terms, and then you ostensibly, under contract law, have to have the opportunity to dispute any of the terms and come to a separate agreement. You can't edit a web page. You just have to click accept. Same with your end user license agreements and stuff like that. So these are all adhesion contracts. Sorry for the digression. In Amazon's adhesion contract, item number 5, identifying yourself as an associate. I'm going to go ahead and just read this to you. It's just one paragraph. You must clearly state the following on your site or any other location where Amazon may authorize your display or other use of content. Quote, We are a participant in the Amazon Services LLC Associates Program, an affiliate advertising program designed to provide a means for us to earn fees by linking to Amazon.com and affiliated sites. End quote. Except for this disclosure, you will not make any public communication with respect to this agreement or your participation in the Associates Program. You will not misrepresent or embellish our relationship with you, including by expressing or implying that we support, sponsor, or endorse you, or express or imply any affiliation between us and you or any other person or entity except as expressly permitted by this agreement. By having the basic line at the beginning of the show saying that it's brought to you by the Madcast affiliate, Amazon affiliate page, they violated the terms of service. I mean, flat out violated it. Even by mentioning the affiliate page on the podcast, they violated the term of service. I assume from Amazon's perspective, this is because, you know, if you go through the Madcast Media Network to purchase an Amazon purchase, you've then cut into the sales that Amazon would have had otherwise. Like if I'm going to buy a $50 jacket and I then go to my favorite podcast, The Best Debate in the Universe, which is so great, and I click on their Amazon affiliate page, suddenly the $50 that was going to be processed through Amazon has a small amount cut out and reserved for the Madcast Media Network, as opposed to just all of the associated fees going to Amazon. So they're doing this affiliate program as a way to generate revenue for the user, but also to drive traffic that might not otherwise go to Amazon from the user's audience. This is an outreach program for Amazon, not charity work. So they don't want people mentioning this on the site because they're not trying to get people who would already be going to Amazon to make a purchase to basically force Amazon to give a small amount of cash to Maddox. I mean, no one wants to give money to Maddox. Maddox is an idiot. So that's why this term exists. He clearly violates it by having the tagline. I mean, this is straightforward stuff, and I assume this is why he no longer has an affiliate page on Madcast Media, or an affiliate link, I should say. I'm guessing that Amazon terminated it. I don't know for sure, right? This is speculation. But other than having Amazon terminate it, there seems to be no reason that his free money train would go away. So that is the answer to that question. I hope that helps Mr. or Mrs. Steep Descent. I hope that helps you figure out what I was talking about. This is not nefarious. It's unrelated to the lawsuit at hand, and it's just kind of a jab at Maddox's general understanding of I guess really anything, of the law of contract, of how business works, of basic navigation of business relationships. This plays into probably a lot of the breakdown of the biggest problem on the administrative side that we don't get to see too much of. We get windows of it, and hopefully in an upcoming video I'll be talking about some of that stuff. But I've mentioned before just the way general partnerships work is that the partners involved have equal ownership rights and an equal ownership interest, no matter how much money or resources they bring to a particular thing. We saw in the lawsuit that Maddox alleges that he created a show and basically invited Dick on it. And that's kind of a one-sided explanation of how that occurs. Of course, Dick's show is Dick's version of the story is completely different, right? He talks about how basically he had encouraged Maddox to create a podcast and thought that people would really like to see it. He had this massive audience, and Dick thought that it'd be a good way to reach them in a new way, kind of keeping up with the times. And then he basically asserts that he and Maddox started this show together, not that he was ever subservient to Maddox in some sort of way. And general partnership. In the lawsuit, Maddox asserts that he brought a fan base and money and all this stuff to the thing, and that Dick brought basically nothing. Well, that's great. Even if true, a partnership agreement, which is You enter into a basic general partnership agreement when you don't have a contract saying otherwise, or an operating agreement saying otherwise, or some other organizing document. If you just go into business with someone kind of on a handshake or an oral agreement to do some things, then you're in a general partnership, and it doesn't matter how much each person brings. It's a co-ownership. So Maddox doesn't understand that, and I think this is just a common theme. Maddox doesn't seem to understand the way business works. He doesn't understand how to, clearly doesn't understand how to monetize the massive fan base that he had in an effective way. He didn't seem to capitalize on the fact that he had produced a New York Times bestseller. He didn't capitalize on monetizing his website in any way. He sold T-shirts and hot sauce, which is great. And some of his T-shirts are really funny. But, he didn't seem to navigate those waters very well. So that's what I want to get at here. It was a light jab at Maddox with the Amazon thing. But the next one is a little bit different. This is a question from Wild Matsu. And he says that I mentioned lying to the court multiple times in episode 5. And I mentioned it in previous parts as well. And all I say is that it'll go over poorly. Then he asks, isn't lying to the court perjury? Isn't it a crime in and of itself? Or does that not apply in this case for some reason? So those are really good questions. And I have to give the lawyer answer to all of them. And the answer is it depends. So some examples of, or I don't want to say examples, going from the lawsuit, what I was talking about with the misleading the court specifically was Harry's and his representation of the Harry's ad revenue that he's blaming Dick for losing. He's saying that Harry's ad revenue should have come out to about $7,200 per month, but a casual review of the episodes, and I believe I've had this confirmed from people who've sullied themselves by watching or listening to the entire episodes of Biggest Debate. But basically, Maddox had Harry's as a sponsor in 2 episodes, 15 and 17. The dates on those episodes are September 12th, 2016 and September 26th, 2016. Now, in the lawsuit, Maddox alleges that Harry's canceled their sponsorship agreement on January 9th, 2017. That may be true. He may have gotten an email on January 9th, 2017 from Harry's stating that they were no longer going to sponsor the show. But let's be honest, Harry's hadn't sponsored an episode since September 26th. And so what Maddox does, though, is he represents that Harry's is paying per 1,000 downloads $45, and that amounts to $1,800 a week, $7,200 a month at a given download rate of approximately 40,000, right? So there's no way that episode 15 and 16 are downloading a combined 40,000 downloads per week by the time January rolls around, right? When Harry's drops its sponsorship. So it really looks like Maddox is misleading the court if he's even being honest about how much they're paying in the first place. It looks like what he's trying to do is make Harry's out to be a fat cat, source of ad revenue. But I would wager they maybe contributed $4,000 to the show, just based on the idea of taking Maddox's numbers of 40,000 downloads per week and applying it to the 2 episodes that they sponsored. That just comes out, and then some trickle downloads afterwards. That comes out to this idea that he's got about $4,000 coming in from Harry's total. Now, again, I am not privy to any of Maddox's arrangements with Harry's. I have to go only by what I see in the lawsuit and only by what I can find through research, which is that Harry's is listed as a sponsor on 15 and 17. So, what Maddox has done, is it lying to the court? That's the question, which would be, lying under oath is perjury. That's the question from Wild Matsu. Isn't lying to the court perjury? Yes, a lie to the court is perjury, but in the legal world, a lie is not always straightforward. The reason I termed it as misleading the court is because Maddox may not be lying, right? A lie would be to call Harry's a sponsor when they weren't a sponsor, to state that Harry's gave them a particular amount of money when they didn't. But he doesn't quite word it that way in the lawsuit. He words it more of, this is the potential earnings that could have come from Harry's. But, so it's not necessarily a lie that would constitute perjury. I mean, it could be. A judge could determine that it is. I don't think they would. I think what they'd look at this and say, okay, they'd take it kind of at face value, and then, Dick's legal team would have the opportunity, should this go to some sort of trial, or even in some preliminary pretrial motions to dispute some of these claims, they would have the opportunity to maybe attack this assertion that Harry's was this loss of revenue that was caused by Dick, one thing, and two, that it was substantial loss of revenue. And if their legal team makes a good showing of it and is able to, either through just basic research or through some discovery, find out that Maddox is highly inflating the amount of money that Harry gave, and then posing that as a potential earnings, even though there's no demonstrated history of those earnings, the court would likely stray towards determining that he misled the court in a pleading document, which would be the complaint, and that carries some risk. Now, what does that mean? Yeah, I say it won't go over well. Well, at the very least, it really damages the credibility of one of the parties when the party misleads the court, and they suggest to the court that a thing is a certain way, and the court finds out no, like not even close to that way, then it damages their credibility in all things. And sometimes a judge will yell at a party for that, and that's usually funny because judges are old and cranky, and when they yell at people, it's worth a laugh. What can actually happen, though, a step further than just being berated by the person who's going to determine if you're a liar or not in the rest of your case, is a judge could impose sanctions or find that Maddox is maliciously misrepresenting things, and technically they could do a finding of perjury. Like I said, it's hard to get to a perjury finding from what's stated. The standard of proof is really high, and Maddox would have an opportunity to kind of explain himself and mitigate the chance of it being perjury. It's possible. It depends on how pissed off a judge is, and they can be pretty angry people. But I think in this case, the most likely outcome is that it just reflects really poorly on Maddox, damages his credibility with the judge, with any jury, any fact finder that's involved in the case. It gives Dick's legal team a foothold. I mean, there's a ton of footholds in this document. It's not like they need some specific thing, but it's just one more point where they get to drive a wedge into this mess and really draw out some criticism and attack the character of Maddox without attacking his character by pointing out a misrepresentation in a pleading document. This isn't like an excited phrase that they said while being questioned, in a high pressure cross examination or a high pressure deposition where they make some statement that they can then say, I was under a lot of stress, I was tired, I didn't mean to mislead the court, I apologize. This isn't a pleading document. This is where, again, I've kind of hammered on this. This is where you get to put your best case forward, and that's important to remember. This is the best case, the best one that they could come up with. It's where you have the chance to lay out in the most biased way all of the evidence that you have. And this is what they came up with. That's the best cards that they have, presumably. I mean, I'm sure they'll think they have more cards available, and maybe they'll find something on Discovery. Maybe that's in their plan. I don't know. But this is the best card they could put forward right now. And that's really problematic for them. And so, yeah, to have that, this is your best prepared statement, and then basically underhand pitch to the opposition this opportunity to go to the judge and say, no, let's talk about this Harry sponsorship. There's no way this accurately reflects reality. He's misrepresenting this, and he's doing it deliberately to try and increase the amount, make my client look bad for a sponsor that he lost back in September, just because they sent an email in January. I mean, these guys hadn't sponsored a show since September. There's no way that their lack of sponsorship is a result of the actions of my client or even his fans. That was an excuse for them to get out of a relationship that had been going down for a long time. It just gives Dick's legal team a nice target to start blasting with a hammer. And again, it's indicative of Maddox's understanding of how law and business seems to work, or his lack of understanding about how these things work. And yeah, I just really, I think it'll go great for him. You know, I've run into this a couple times recently, just in the past year even, where I had an opposing party misrepresent to the court some facts. One was a rental case, and they suggested that their client had a rental relationship with my client, who was a landlord. When in actuality, my client was not a landlord. He was a guy who invited someone who was homeless to stay in his house. And then when they just, were sitting around on his couch for the next 20 days, he asked them to leave, and then they sued him to try and get the state to force him to keep them at the house, right? And they wanted all sorts of money and everything like that. In their pleading document, they vaguely worded the agreement that they are claiming, and the way they worded it made it look like this person had paid my client some rent money that was agreed to at some point. Our position was and still is, because it's the truth, that there never was an actual rental agreement. No money ever changed hands, and that was ultimately damning for them. Because no money changed hands, the judge was furious that they had suggested that money might have changed hands, because had they made some sort of payment, it would have gone a long way in establishing a rental contract. Well, they didn't. But they didn't tell the judge that. And because of that, my client was burdened by having, to deal with this lawsuit, by having a sheriff show up and force the entry into the property for this other person to get items out and stuff like that. It was disruptive to my client's life. It was disruptive to the court. The judge didn't like it, and ultimately dismissed the case largely based on that, and then spent about 5 minutes yelling at both the other party and their attorney. So that was a bad decision. And then I had another actually a landlord-tenant case recently where the opposing party had misrepresented my client in stating that my client had done some things, particularly assaulting them. The real misrepresentation came with what followed the alleged assault, where they claimed that they contacted police. Well, when you contact police, right, they do something called an incident report or response. If they don't send a squad out, they may not have an incident report, but they usually have a log of the calls, where they came from, what time they came in, what date, what the issue was. And then, if they responded in any sort of way, they would write all this down and have some sort of thing. Well, they claim that police officers came out to the house to talk about this assault, and yet they didn't produce any documentation that this had occurred, right? And so they're talking about a squad car coming out to a house at night, responding to a call in for an assault with a deadly weapon from my client, and there wasn't an incident report, right? So no officer ever came out to the house. The assault never occurred. Actually, what was worse for the people involved is that my client was there and they were not. So they alleged that my client assaulted them even though they weren't present at the home. All of this went very poorly, right? And yeah, in that case, the judge maybe could have found that they were perjuring themselves, lying under oath. But it ultimately boils down to, in this case, it was a he said, she said, right? We couldn't prove that they weren't there. We didn't have video of them not being there. And we couldn't prove specifically that a police officer had not come out. But we cast a huge amount of doubt on the idea that they were present, since they didn't have any supporting witnesses and there wasn't a police report. So, being that there's no police report, if there was, the incident report would include that they were home at the time, and they weren't. The incident report didn't say that they were. So the judge is faced with a decision at that point. Do I try and slap these people for perjury, which then becomes a criminal charge, and they have to prove beyond any reasonable doubt that they were lying with the intent to lie, not just making some sort of misstatement? Or do they just kind of yell at them and consider the idea of sanctions? And so, that's what's on the hook for Maddox in this case. The possibility of sanctions, the funny possibility of being yelled at by a judge who might already be ticked off that they're bringing this case to New York when it doesn't make sense to be brought in New York. As the judge reads through these claims and sees this person was mean to me on the internet, and therefore I'm entitled to $20 million, a judge might already be in a sour mood. So we'll see. Like I said, I say that it doesn't go well when you misrepresent things to the court, because it doesn't. These things come to light. You're in an adversarial environment, and the other party is going to latch on to any stupid missteps that you make, any wrong statements that you make, and anything you can't prove. Whew, it's going to be rough. And I think a lot of the things in this lawsuit are going to be rough for Maddox. But we'll see, or we won't, because it'll be dismissed for improper venue and lack of jurisdiction, which it probably should be for basically everyone except maybe Asterios. But even him, I think he has a claim for dismissal for other grounds. But yeah, I think most of the parties should be dismissed for lack of jurisdiction. And if that's the case, we may never get to see the comedic results of a judge screaming at Maddox. But we can dream about it, and those are good dreams. So hope this video is informative. I will be considering doing some drill down videos of specific parts of the lawsuit coming up here, just to kind of tackle specific issues and then go into how you go about countering and fighting them, kind of from a legal perspective. And I previewed all of this in a drunken stupor in the first couple videos, which was a lot of fun. But thinking about really drilling down into specific sections and talking about the claims and talking about just what it means to not have any evidence of these things. So hope you enjoy the video, and keep watching, I guess. Eventually we're going to move off the topic of this lawsuit, but as long as it keeps providing interesting material, we'll hang around on it for a while. So thanks a bunch. Y'all have a good night.